again. The reason I became a lawyer was because I wanted to be a better social worker. And in the neighborhoods that I used to work, being a social worker wasn't enough to help all the cases that I had unless I had a basic knowledge of the law. And especially when it came to issues that had to do with entitlements, issues like Medicaid, Medicare, Social Security, public assistance, which all of them, your clients, besides all the other issues that they may have, they will have problems in following up with the paperwork that is required from all these agencies. Different agencies sending almost monthly paperwork for them to do. And sometimes they forget about it. Sometimes they're too busy with the children, etc. And they forget to give it to the social worker. And even when the social workers get the paperwork, the social workers don't know what to do with the paperwork besides following the instructions and filling out the forms for the client. Now, we're going to be talking about entitlements. Entitlements means that the benefit that your clients are receiving is a property legally. Is their property. So what we're going to do is that we're going to go through what defenses you have legally in order to protect that property, that entitlement, which can be taken away if you don't follow up with the requirements of the agency that is giving you that entitlement. That doesn't mean that they can take it away whenever they want to. And they usually, when they take it away, is because the client didn't know how to respond to it, number one, and didn't know their rights. So this is very simple. What we're going to do today is using legal technicisms in which we can buy more time for you as a social worker, as counselor, etc., to remedy whatever your client hasn't been able to provide to the agency or anything that is not clear. So you buy more time and avoid your client being deprived from this entitlement for a long period of time, which means that once it's taken away, they have to start the whole process all over again. And sometimes it takes months. And we all know that these entitlements are extremely critical for our clients, that even if they don't get them for 1 month, the crisis at home can increase. So this is a must in terms of social work education. And the risk, and we are recording this, so everybody at the school can, all the classes, I don't care what class, can use it and advise their students.
Sorry, Professor, students raise them hand and maybe have some question need to answer.
Oh, okay. Yes, I'm sorry. Yeah, you have to let me know about those things because sometimes I'm just looking at what is happening in my head, which sometimes is very curious and abnormal.
No, I was going to interrupt. That's what I thought, but I wanted to raise my hand at first. But I'll just throw questions at you as you're going because you're usually, that's how you prefer things. Can you like give an example of like an entitlement? Is this like someone isn't getting their like SSI?
Yeah, public
like
assistance.
Form in, so they don't get the like they're not getting cash for like 2 months because the actual form like was wrong. Okay, so I just wanted to make sure I got that.
Medicaid, Medicare.
Yeah.
Social Security is stronger than the typical entitlements because that one you pay for it and is given to you automatically. You just have to make sure that you do respond to whatever they send you. It's very difficult for them to take your Social Security away. It's easier to take your public assistance away and your Medicaid and your Medicare. Social Security, you may use the same strategies if you have any issue, but that's an entitlement that you have been paying for a long time for, and it comes, once you do a little bit of paperwork, it comes almost automatically. So I wouldn't worry too much about that one, but the others that we mentioned before are those, especially when the state is involved, because the state has interest, has financial interest in your entitlement. And it's not that they're bad people, it's just that, they want to make sure that the money that is being sent is used, and there are records that illustrate that the money has been used appropriately, etc. They want to make sure that you didn't die, and they have been sending checks for 3 months, 4 months without hearing from you. So, they have legitimate reasons to follow up. However, the number one issue is that they want to make sure that the state budget doesn't go out of control. And ironically, this is one of the devices that are used in order to save some money, but they have to be fair. And that's what we're going to be talking about. So let's start with the 14th Amendment, which I call the Social Workers Amendment. It's more than the Social Workers Amendment, but for the purpose of this little class is the Social Workers Amendment, because it's something that all social workers should learn when they come to School of Social Work. And this issue of separating law, social work, and social policy, even political science, etc. Everything is combined in social work. So we shouldn't be afraid of bringing constitutional issues to the classes that we have in social work. As a matter of fact, they should be a must, especially when you are working in advocacy. So let's go to it. I'm talking too much. 14th Amendment. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor, and this is the part that is important, nor shall any state deprive any person of life, liberty, or property, that's the entitlement, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So there are three things under the state that the state cannot do: deprive any person of life, liberty, or property. So when you get public assistance, that's considered a property. So they cannot take it because they want to take it. They have to give you due process. What due process means? All this is important, because what I did was that I went straight to the point, and all you have to do when your client comes to you and it tells you, look, they stopped my public assistance, and they're saying that I didn't answer the last 2 letters, but I was busy, I have the kids and that. Sometimes I don't understand what they are doing, what they're asking me. So I just didn't have the time, or I couldn't do it. And I wanted to bring it to you, and I couldn't bring it to you because I even missed my appointment with you for whatever reasons. So first, they cannot take it without first providing proper notice, a warning. Notice that they are about to cancel, to stop the entitlement that you have, unless you do such and such thing. It has to be proper. That means that the name, this is what you're going to check. One of the things that you check first is that the name is exact. Not Joe P. Williams. If it's John Williams and they didn't put the P as you register, well, that's not the one. You can stop everything and get the benefits again until they correct that. If they put the case number, the wrong case number, if it's G44444 and they wrote G44445, that's not proper notice. That's not the case. So you check for those things, making sure that is correct. If they put 440 is apartment 5C, no, it's not 5C, it's 5B. But it got to your apartment because everybody knows who you are, so they know the name and someone put it under. But that doesn't mean that it's appropriate. So it's not proper notice. So you check for all those things. Hi, Sam. Okay. Second, you need to have, well, let's go start with 3. You need proper notice issue of the complaint and the opportunity to be heard. So we went through the proper notice. The complaint is specific. It has to be clear about why you need to go now to administrative court to defend your entitlement, your property. And you need an opportunity to be heard. So what you do as a social worker when this comes is, number 1, you check that it's proper, name, case number, not even a dash in the number, 44-555. They didn't put the dash, you bring it with you. So that's proper notice, issue and complaint, and then opportunity to be heard. And this is when usually, let's say that everything is fine. This is when we need to win the case, even when the proper notice doesn't help you. Now you will have an opportunity to be heard. You go to court, but before you go to court, this is how you're going to win. This is the technical, this is the technicism. Read the letter. Well, see any mistakes in names, address, case number, they all must be correct. If everything is correct, number 2, did it arrive at least 30 days before the hearing? Before the hearing. They are going to give you a hearing date. Did it arrive 30 days before? Let's say that it did. Let's give them all the benefit of the law to them. Then count backwards from the hearing date. So what day is today? It's July what?
It's not July.
It's not July, you see? You see why I'm not equipped to teach anything?
It's December 19th.
And this is on videotape. Oh my God. I'm just joking. I'm just joking. December what? What I really don't know is what day is today. So it's December what?
19th.
December 19th. So let's say that by January 19th, it will be 30 days. Let's assume I'm not going to do the math. By January 19th, it will be 30 days. Did it arrive 30 days before the hearing? If it didn't arrive 30 days, that's not proper notice, because you also need time to prepare the case. The client, they are not assuming that the client has a lawyer or he has a social worker They may assume that or not, but they send it to your client. The one responsible is your client. So then count backwards from the hearing date. And what you do is that you ask for it 10 days before the hearing. You have 10 days before the hearing to ask for, let me see, I'll make it correct. You have 10 days before the hearing, you count backwards, 10 days before the hearing. To be more secure, count 15. And then you send a letter. This is how you win. On the day 15, before the hearing, you send a letter asking for the whole record 12 days before the hearing. You send a letter requesting the whole record. Now, this is when you win the case. They won't have the opportunity to put it together on time, to put the record of your client on time. So they must mail it to you and must arrive depending on the jurisdiction, but it's most likely in every jurisdiction at least 7 days before the hearing. You ask for it 12 days before, and they are supposed to send it to you 7 days before the hearing. That means, and this is what is important, that they have 5 days to go through the whole record, which some parts of it may be in different files, putting it together and sending it back to your client. That never happens. They never have enough time to do that and put the whole record together and send it to you on time. Remember, you need to have it at least 30 days before the hearing. On the day 12, before the hearing, you ask for the whole record certified letter. Certified letter. Make sure that your agency pays for the certified letter. Don't ask the client to pay for the certified letter. They're about to lose everything. It doesn't have to be certified legally, but it's better when it's certified. It gives you more validity. Also, the stamp is going to be there with the date. They must mail it to you and must arrive to your client home at least 7 days before the hearing, which is unlikely. Now, this is something that I feel bad about it because the workers, and I have friends who work in food stamps, social welfare, public assistance, etc., and they are abused. They have so many records, and the records are not always kept in order. So sometimes they have part of the record in one file, part of the record in another file. They have 30 records that they have to deal with, clients that come in. They are never going to be able to do this on time. First, they're not going to read it the first day when it comes. And most likely, you are going to have the advantage. Because in order to have a proper hearing, and this is what you're going to say in court, you're going to say Your Honor. And by the way, it's going to be a little room. It's not going to be a court itself. It's going to be a little office with a long table. Your client is going to be there. You are going to be there. The public assistance worker is going to be there, Medicaid, Medicare, whatever. It's going to be there with the record there that was supposed to be sent to you. And the judge is going to be there. The judge is not going to defend your client. If you don't know what I'm telling you, the judge is not going to make an argument for your client. And especially when you don't know what the rules are and your client doesn't know what the rules are, he's going to depend on the worker who's going to tell the story about when they send the letters, which is in response, and all that. And then they're going to ask you, do you have something to say about that? You have nothing to say about that, unless that she was busy, that she had an emergency, and things like that. And most likely will depend on the good faith of the judge to help your client or not. Most likely, if there is not a reasonable excuse, your client is going to lose the benefits, and then they have to start all over again. So what you are going to say is, Your Honor, I have a certified letter here in which we requested, according to the law, there are two cases in New York, Rodriguez and Rivera, cases in local courts. And you can say, I'm not going to put you through Rodriguez and Rivera now because it's going to take even longer. All you have to do, according to the case Rodriguez and Rivera, and according to the guidelines of the agency, we must receive the whole record. The client must receive the whole record, if requested by the client, at least 7 days before, 7 days before the hearing. We requested by certified letter that record, and I see the record is there. It's not like they didn't have it in order. The agency has it right here, but we don't have it. So we, under the 14th Amendment and the case Rodriguez and Rivera in New York, we haven't been given a proper notice and an opportunity to be heard properly, because our speech has been limited by them not providing us the record that we need in order to be here. So, Your Honor, because they fail, and this is the letter, certified letter, we want you to please renew again all the benefits and entitlements that my client was receiving, and then give us an opportunity to answer the original letter asking us for information, and that way nobody suffers. But at this point, a decision cannot be made because we didn't get proper notice, we didn't get a proper response, and we advocated for that. This is the proof of it, that we sent the letter, and the agency has failed to allow us an opportunity to defend our client. The judge is going to say, you are right. I'm surprised that you know so much about the law. This is extremely well. And they are going to let your client go and immediately restitute all the benefits. That is a technicism. It's a legal technicism that gives your client more time to answer the letter, because they get letters regularly about them responding to things. That's most of the time, most of the cases that are taken away are because people didn't answer bureaucratic messages, bureaucratic questions, and that's how they lose their cases. So you are using a bureaucratic technique, which is legal, that is supported by the 14th Amendment of the United States and by 2 cases in the state of New York, which are called Rodriguez and Rivera. Don't worry about, you can Google Rodriguez and Rivera in New York. They will give you, it's basically the same thing, but it was also adopted by the Supreme Court in the United States, in the state of New York. I'm sorry, the appellate court. There is no Supreme Court in New York. It's an appellate court. So that's how you do it. Questions?
Sorry, Professor. There are only 5 minutes limit because the Zoom has a time limit. So control the time. We only have 5 minutes.
Okay.
Mm-hmm.
Oh, there's chat questions here. 1 second. Oh, that was you, Jingham. Okay. Was that clear or not?
Yes.
Is that helpful?
Yes. It makes me sad that it's a lot of like manipulating the system, like you were saying. But it works and it's fair. So
Well, my first case, I won, and he was doing that. And I was a student in law school. They sent me to do that case. And I won, and this is the technicality that you can use. I hope that we can distribute this throughout the school. I don't know how, but we can offer it so everybody knows these things, okay? So look, I won't take you much time. Christopher, are you okay?
Yeah, I'm okay. They were very helpful.
Yeah? I wasn't confusing?
No.
You know, I can be confusing.
Are you gonna send the document and like the recording?
Yeah.
Thank you so much, Professor. Thank you.
Okay. Jingham told me that is enough. Sam, are you okay? Was it good? Was it good enough?
Yeah, yes, it was good enough for me. Thank you.
Okay.
But I am questioning the 12-day time. Like, there's no legality around that they have to have 5 days prior to the 7 days.
No. You need to have it at least 12 days.
Okay.
Because it has to be, it cannot be a trick. You see, they cannot play that trick. We can play that trick. So they have to give you a reasonable time to prepare. You know, don't send it to me in the morning, the day before. You know, don't give me 24 hours when I asked for this a week ago. You know, you're giving them a whole week to send it to you. And and by the way, that is the rule in the court.
yeah.
Not, you see, that's a rule by the administrative court in New York. I don't know how they do it in other states.
Okay, thank you.
Okay, don't feel bad. You're defending your client. And it's legal. I'm not saying anything that is illegal here. But you need to learn how to fight back. We all need to do that. We learn every day. Okay?
Thank you, Professor.
Okay, God bless you all. See you next
Happy
semester.
holidays.
Okay.
Thank
See you in the
you.
new year.
Take care. Bye-bye.